Welcome to another episode on the Law Rapport. Today is really a continuation of episode 50. In episode 50, I dealt with the grounds for divorce in the Turks and Caicos Islands, and at the end of that episode, I promised that I will deal with property division or the division of matrimonial assets post divorce. And so today, this episode will focus primarily on the division of matrimonial assets in divorce cases. And so this episode will be episode 50A. But before I get into the meat of the discussions, my usual disclaimer. This is not legal advice, should not be construed as a legal advice. For legal advice, please contact an attorney of your choice. Welcome back. Now, the division of matrimonial assets in divorce proceedings is also known as property adjustment or property adjustment orders in connection with divorce proceedings. And this is covered by the Turks and Caicos Islands Matrimonial Causes Ordinance. Section 28 of the ordinance grant the powers to the court to make the following orders. An order that the property to the marriage shall be transferred to the other party, to any child of the family, or to such persons as may be specified in the order for the benefit of such child. And this will be in a case where the property may be transferred for the benefit of a child, but transferred to an adult to be held in trust for that child. The court can also grant an order that settlement of the property is transferred to the child directly. The court can also make an order varying any benefit of the party to the marriage and of the children of the family, or either or any of them. The court may also make an order extinguishing or reducing the interest of either of the parties to the marriage under any settlement. Now, the court is required, both in law and in fact, objectively, to strive to achieve fairness in making a determination as to how matrimonial property or matrimonial assets are to be distributed or shared among the parties. Judges have a wide discretion in reaching an equitable outcome. Notwithstanding this discretion, it is sometimes often difficult for judges when dealing with an application to have family assets distributed after a divorce. Nevertheless, the court must follow the guidelines that is set out by statute and any case law that is relevant, which deals in the past and past cases with the points that are to be adjudicated on. In the Turks and Caicos Islands, the court has a duty to consider all the circumstances of the case in addition to the factors that are set out under Section 29 of the Matrimonial Causes Ordinance. So, the starting point is an equal division of matrimonial assets. Fairness does not, however, necessarily mean that an equal distribution of assets on a divorce is appropriate in every case. If there is a good reason, a court may or should depart from the equality principle and make a different order. There should be no discrimination between the parties' respective role in the relationship. For example, if one party is the sole breadwinner and another party is a homemaker, their roles are regarded as equal. This principle emerged from the landmark case of White and White in 2001. The first consideration that the court must have in divorce proceedings and ultimately in property settlement proceedings is in needs of any dependent children of the family. If there are no children of the family, it makes it a little easier for the court to proceed. The court will look at meeting the needs of both parties, including their housing and their income needs. If these needs can be met from existing assets and there is a surplus, then the court may consider the origin of certain assets in determining how the remainder of the assets are to be divided. This will include whether the assets are matrimonial assets, that is, assets that were acquired during the marriage from joint enterprise or the joint input of both parties. So one of the considerations of the court in determining or in dividing matrimonial assets is that the court must ensure that the assets are truly matrimonial assets or truly matrimonial in nature. Assets acquired outside of the marriage, whether before or after separation, or even during the marriage by way of gift or inheritance, may be considered. However, if one party during the marriage receive a gift or inheritance during the marriage, that doesn't make that property or that gift or that inheritance matrimonial property. If there have been unequal contributions due to some of the marital pot, so to speak, being pre-matrimonial, for example, this may be taken into account in deciding whether there should be a departure from equality. So if one party comes into the marriage and meets one party with certain assets or certain money in the bank, and then they contribute subsequently, the court will have to determine if the whole pool then becomes matrimonial assets to be divided between the parties, or if the court must consider just the contribution made by the party that coming into the marriage and meeting assets already established. The court is so here's a typical example. A couple get married, one already owns a house. Both parties live in this house. Now the house has a mortgage. The party coming in to the marriage now begins to contribute to the mortgage, now began to pay for renovation, now pays or contributes towards an addition to the house. Maybe the family get a little large and they have to expand and so on, or an extra room. That party now has an interest in that house, and that house may have changed its character from being solely owned by the party who initially acquired it to now becoming a matrimonial asset, which is likely to be divided if there is a divorce. Is obligated by law to consider whether a clean break is appropriate. If a clean break cannot be achieved due to one party still having unmet needs, the court may order spousal maintenance for a fixed period, or in increasingly rare cases, indefinitely, and therefore differ from the clean break principle. Spousal maintenance is, however, always a variable in the future if circumstances change. Achieving a clean break does not mean that there may not be child maintenance, because party would still be obligated to maintain a minor child of the marriage. So what is a clean break? A clean break settlement essentially means that parties will have no financial ties to one another once a financial order has been made. It allows the party of the marriage, or in case of civil partnership, to move forward financially independent of the other party. Now, let us look at the factors that Section 29 of the Matrimonial Ordinance directs the court to take into consideration. One, the court must take into account the income of the parties, the earning capacity, property and other financial resources which each of the parties to the marriage has or is likely to have in the foreseeable future. Before the court is able to decide to divide assets, the full extent of those assets must be disclosed. The value will need to be determined or agreed for the assets, such as a former matrimonial home, other properties, businesses, trust assets, chattels, or pensions. So there should be an evaluation of the property that form part of the matrimonial property. Or there could be an agreement between the parties as to the value of the assets. The court will also need to ascertain the true nature of the parties' income from all sources of employment, bonuses, self-employment, benefits, interest on assets, etc. So if a party is working as a waitress, for example, and is collecting a base salary, and at the end of the month they collect tips or gratuities or what have you, that must be disclosed. If somebody is the manager of a company and every year they collect dividends, or they're shareholders and they collect dividends, or they collect a bonus, etc., that must be declared in addition to the base salary. The court must consider the age of the parties and the duration of the marriage. The duration of the marriage may also determine the distribution of property. Age will affect a party's earnings, their mortgage capacity, because the older they are, the less likely they might be to attain a mortgage, and thus it may affect their ability to achieve true independence. It may be crucial when assessing the income or capital needs that an important factor in this consideration may be the pension scheme of the parties, or how soon one or more of the parties are to retirement. As mentioned before, their mortgage capacity can be crucial to the issue of whether a party retains a property or whether the court orders that a property be sold. And Section 30 of the Matrimonial Ordinance empowers the court to order sale of matrimonial property. In this case, the assets or the proceeds from the sale may be distributed equally or proportionately. The court may order that after, if there's a mortgage on the property, after the mortgage has been paid out and other expenses associated with the sale, then the proceeds be divided equally among the parties or according to the proportion of their contribution as the court sees fit. In the case of a very short marriage, the court may seek to return the parties to their financial position before the marriage and impose a clean break settlement. However, this may not be possible in short marriages where there are children and where the ability of one parent to immediately return to work is hampered by childcare needs, or where one party cannot support themselves in the immediate or short term. The court is directed by the ordinance to consider any physical or mental disability of either of the parties to the marriage, because this may affect one party income or earning capacity, or how they will take care of their expenditure or accommodation, etc. The court is also directed to consider the contribution which each of the party has made or is likely to make in the foreseeable future to the welfare of the family, including any contribution by looking after the home or caring for the family. Contributions include the degree to which assets are non-matrimonial. If assets were brought into the marriage by one party at the beginning of the marriage, or they were received during the marriage by way of gifts, inheritance, etc., this may be relevant in assessing the overall financial situation of the parties. The court is directed to consider the value to each of the parties to the marriage of any benefit which by reason of the dissolution of the marriage that party will lose any chance of acquiring. This can mean, for example, the loss of pension rights that the party may have been entitled to upon the death of the other party if they had remained married. The court is also directed to consider the conduct of each of the parties if that conduct is such that in the opinion of the court it would be inequitable to disregard it. Now, this factor, conduct of the parties, is very rarely considered in the division of assets in divorce proceedings. This does not include adultery, and it only applies in the most extreme forms of bad behavior where it would be inequitable for the court to disregard it in settlement of the parties' financial position. Bad conduct or bad behavior by one party or the other will only be taken into account in very exceptional circumstances when decided how assets should be shared after the divorce or dissolution of a marriage. What exactly does this mean? It is rather difficult for a party to succeed in an allegation of bad behavior or conduct in financial remedy proceedings. And as previously mentioned, whilst personal conduct such as adultery or even unreasonable behavior may be valid reasons for a divorce, they do not count as enough to establish bad behavior or bad conduct. Much case laws has been centered. Much case laws have been centered on the threshold of behavior that must be met to succeed in running or in making a successful bad behavior or bad conduct argument. Essentially, it applies to only the most extreme forms of bad behavior, where it would be inequitable for the court to disregard it in the settlement of the parties' financial position. So what sort of conduct would constitute bad conduct? For example, in the case of H&H, the conduct of a husband who stabbed his wife so that she was unable to walk and refused the sale or letting, meaning renting, of the family home was described as conduct at the very top end of the scale because of its financial consequences and the wife's earning capacity, thus entitling the wife to a higher priority than the husband. In the case of A and A of 2012, failure to disclose assets and resulted in one party being awarded 50% of assets plus an uplift in respect of the other party's conduct. So by failing to cooperate with the process and by failing to disclose assets, one party was penalized. That was held to be bad behavior or conduct that could be taken into consideration in determining how the assets should be described. Financial dissipation through gambling has also been held to be bad conduct in the case of M&M in 2006. So if one party is a compulsive gambler or habitual gambler, what have you, and they gamble away the matrimonial assets, that could be construed as bad conduct, resulting in the other party being awarded a higher proportion of the matrimonial assets. However, the examples given demonstrate how rare it is for bad behavior conduct to apply. And it is important to distinguish this narrow legal concept of bad behavior conduct from other faults like adultery, lack of emotional support, which while they could be hugely upsetting, it would not be relevant in the division of matrimonial assets. So a person can say, well, that person cheated, that person committed adultery, that person was unfaithful, and because of that, I should be given more of the matrimonial assets, or I should be able to keep the matrimonial home because it was her fault or it was his fault that the marriage went haywire, went off the rails. No. The test for establishing bad behavior is very high. And as previously mentioned, if the court feels that the only equitable solution is to sell the matrimonial assets or the matrimonial home, etc., Section 30 of the Matrimonial Causes Ordinance empowers the court to make such an order. Here is where I will leave it for today. I hope I have been of some assistance to you. If you have any comment, please leave it in the comment section below. And I will see you in another episode. Thank you.